If the other parent is doing something illegally, that's an issue.
Oh.
And there are cases in which one parent have a lot more financial disposable income that they can continue to litigate and encourage witnesses not to come forward or to testify in their favor. And unfortunately, the parent who doesn't have the funds to fund ongoing decade-long litigation process, the kids get hurt, and the courts are left to, they can only hear what evidence is presented to them. And so if pro se litigant, which is a party that is not represented by counsel and they represent themselves, they are held to the same standard as an attorney. So if a party is coming to court because they have the finances to do so, whether they have factual grounds or not, but they have painted them in a way that the court sees them as a legal grounds for them to flip custody or keep the other parent from the mom or the dad. The party who represents themselves, you don't know what you don't know. And they oftentimes are at a huge disadvantage because they are not able to represent to the court the proper legal argument to combat the other side. And I think that's the hardest thing that I see, especially most recently. And it really is harmful to the kids. I mean, all the money in the world and all the counseling in the world can't fix what parents break in their kids. And that's really hard to see.
And the other thing is the other piece of advice I would say is don't ignore the circumstance. We do have parents, you're doing your day-to-day, you're doing your life, and you're trying to just survive and get by and raise a good, competent kid. And then a lawsuit comes up that you are not expecting. You're not financially prepared for it. You're not emotionally prepared for it because it's always shocking and it's always scary. Don't ignore it. For goodness sakes, don't ignore it. That is the last thing you can do. Even if you only have like a tiny amount of bandwidth, contact an attorney and at least get some advice about how to proceed, at least to the first step, so that you can make sure you don't get defaulted and that you're not having to then run back up the mountain. Because if you get to a position where you've buried your head in the sand just because, and we all understand that. We have all had those moments in our lives where we don't have the mental capacity to be able to deal with one more thing. But these are your children.
And default, just so it's out there, is you fail to respond to the lawsuit. So the other parent, and if it's a modification, the other parent can take an order to the court at any time after your answer period has passed and present an order to the court that defaults the other parent.
Which basically means they get what they want.
Yes.
Without you being able to say, this is a terrible decision for my children. They get to walk in and go, yeah, she didn't respond. She's not doing anything. So here you go, judge. I want custody and I'm going to do all these things. So do not.
And if you defaulted, you can't appeal that. You can appeal, but you're not going to win.
No, it's very hard to come back from that and explain to the court that you're the parent who should be the person to make all these decisions for your kiddos, but you couldn't manage to respond to a lawsuit timely. So don't ignore.
Agreed.